Welcome to episode 1 of this landmark series, the Basic Structure Doctrine, the soul of the Indian Constitution. I am Amod Bidhuri, and today we are not just beginning a legal lecture, we are beginning a journey into the heart, soul and foundation of Indian Constitution. Let me start with the question. Have you ever asked what protects the Constitution from being rewritten by a brute majority? What if one day Parliament decides no elections, no fundamental rights, no judiciary? Can that be done? Shockingly, at one point, the answer seemed to be yes. That's where the basic structure doctrine comes in. Not found in the Indian Constitution, not written in any of the articles, and yet the single most powerful shield our democracy has. Before we understand what it is, we must understand why it had to be born. Our Constitution is not a piece of dead parchment. It's a living, breathing organism. It adapts, it responds, but like any living being, it also needs an immune system. The immune system of Indian Constitution is judicial review, and within judicial review, its backbone is the basic structure doctrine. Without it, there would be no limits to political ambition, no protection for individual liberty, no guarantee of free elections, free speech, or even justice. Now here comes the real constitutional dilemma. The Constitution gives Parliament the power to amend it under Article 368. But can Parliament rewrite it entirely? Can it destroy its spirit while pretending to amend it? That was the legal battle that led to the creation of this doctrine. The doctrine called Basic Structure of the Indian Constitution. This was not just a courtroom debate, it was an existential crisis for Indian democracy. And it exploded in the case that changed everything. Kesavananda Bharati vs. State of Kerala, 1973. Let's rewind a bit. In 1951, Parliament inserted the 9th schedule to protect land reform laws. In Shankri Prasad of 1951 and Sajjan Singh of 1965, the Supreme Court said Parliament can amend fundamental rights. But in Golaknath vs. State of Punjab, 1967, a bold bench said no, Parliament cannot amend fundamental rights under Article 368. Tensions were rising between the Parliament and the Judiciary. This tension was not academic, it was political. Indira Gandhi's government wanted unrestricted power to amend. The Judiciary wanted to preserve constitutional values. And then came 1973. A monk from Adnir Mutt in Kerala filed a case and the nation held its breath. In the Kesavananda Bharati case, 13 judges sat together and the largest bench in the Indian judicial history, and arguments went on for 68 days, and what emerged was history. A single ruling changed India's constitutional history. It said clearly, Parliament is powerful but not omnipotent. There are invisible lines it cannot cross. Those lines are the basic structure. What constitutes basic structure? Supremacy of the Constitution, republican and democratic form of government, secularism, separation of powers, judicial review, free and fair elections, federalism. These aren't just legal terms, these are the pillars that keep the Indian Republic standing. But let us be honest, this doctrine is not without criticism. Legal scholars and some politicians have accused it of judicial overreach. Criticism one is that is not found in the Indian Constitution. They argue, how can the judiciary invent something that's not in the text? Criticism 2 is limits parliamentary sovereignty. In a democracy, isn't the elected parliament supreme? Doesn't this doctrine let unelected judges override the will of the people? But democracy is not about majority rule. It is also about constitutional morality. That's why Ambedkar said a constitution must place limits on temporary majorities. As B.R. Ambedkar said, the majority may become a tyranny. Let's fast forward it to today, when we debate constitutional amendments, executive interference in judiciary, electoral reforms and even internet freedom. The basic structure doctrine is often the last line of defense. With examples being NJAC was struck down by the Indian judiciary and electoral bonds scrutiny in 2024 by the Indian Supreme Court. It's a doctrine not just of law but of hope. It protects the idea that no one, no government can override the constitutional soul of India. In the next 9 episodes, we will explore how the doctrine evolved in later cases like Indira Gandhi vs. Raj Narayan, Minerva Mills case, Bommai case, NJAC case, what lawyers, judges, and scholars argue for and against it, how it protects and sometimes complicates Indian democracy. This series is more than just lectures, it is a constitutional awakening, because understanding this doctrine is understanding how fragile democracy is and how fiercely it must be defended. If you care about India's future, its democracy, and its justice system, this is the episode and the series you must follow. Subscribe and share this episode, leave your views in the comments, and let's start a movement of legal awareness. And in the next episode, we take you inside the courtrooms, the chaos, and the constitutional climax of Kesavananda Bharati versus State of Kerala, the case that changed India forever. Thank you. This is Amod Bidhuri, and I will meet you in the next hearing.